Gian Diego Pini will go now on the disclosure of the data at public events. We still have, let's say, I don't know, 20 minutes would be enough?
Absolutely. No, I'm going to be brief, in addition to not having really much time left. Actually, probably we're already over time. But also because I know I've been at a lot of conferences and I know that this is the worst time to actually be speaking or listening. So I'm gonna be quick in any event. I mean, the very interesting thing about this presentation is that you would not think about antitrust. You would not, if you're disclosing data to the public, it's a press release or it's your website. Or it's maybe an article on a newspaper that you are contributing to, right? So in all of these cases, you wouldn't think about antitrust. First of all, because most of the time this is unilateral, so you would think, yeah, I'm doing something, but I mean, I'm not looking at competitors, I'm not speaking to them, I'm not trying to, agree with them, I'm not having any impact on the market. So it is a unilateral behavior, but it will never be considered an abuse of dominance. There's no merger, so it's kind of like an area where you would think I'm safe. You would be right in a good 99% of the cases. It is true that 99% of public disclosure of data, including of very, very, very confidential and competitively sensitive data, most of the times it's fine. I mean, if you decide that you want your competitors and your customers knowing your business secrets, that's your problem. But of course there are exceptions, right? So keep in mind that we are all working, and I'm gonna try to switch to cases relatively quickly so you can see when actually that was an issue. But in general, take into account that this is a very, very niche situation. So it doesn't, normally you wouldn't really care about antitrust, but there are exceptions. So first of all, I'm going to discuss a little bit about this. A little bit, there are a couple of cases about this, but so the disclosure at conferences, let's say, main trade association conferences, that's kind of the idea. Consider that this is a little bit less public, so it kind of gets a little bit out of the public sphere and it gets into a little bit more private, discrete number of subjects that gets access to it. In any event, even if that gets out of the conference, it is not in the same form. In any event, even if it gets out of the conference and gets to, for example, consumers, they may not know what to do with the data. So this goes closer, gets closer to the, let's say, cartel situation. So it is a limited number of people that gather together and speak about something. And if they speak about something that is competitively sensitive, there may be an issue because it's just them knowing the information. So the most interesting part is when you are actually giving access to everyone. So everybody has this information. So it's maximum transparency. You're just giving the information. And if you think about it, this is interesting if you, in the e-commerce sector or any sector that has relevance online, for example, insurance, banking, all of these sectors are getting more and more and more transparent. So you will have access to very detailed information, airlines, so you will have access to very, very detailed information about prices, you will be able to compare them, and of course, as a competitor, you do have access to the other the other companies' prices. So the idea is, if I know everybody's prices, and they know my price, and each other knows each other's prices, I mean, wouldn't they just, reach a common understanding and get to let's say, a common parallel conduct, so common prices across the industry? Yeah, maybe. So, but at the same time, so this is why it is so interesting for both companies and consumers. So, if it gets big, so in cases where you have a very concentrated industry, for example, and you have 3 players in it, and then you increase transparency, you give maximum transparency. You say, I'm pricing my sack of cement at like €5, and then the other one says, actually that's a very good idea, I'm going to price it at €5 as well. And then the other one says €5 as well. Then, you're a customer of of cement, and you think, yeah, okay, I mean, I didn't really want this transparency to be there because now they know each other's prices and they're just going to price all the same, and I have no alternative. So it may lead to that, but if you get there by just adapting, so there is no communication about aside, and it is just a unilateral behavior in which you just say my price is X, that's it. It is very unlikely. I mean, of course, you never know what the authorities will do, but it is very unlikely that there will be an antitrust case, because the antitrust case would be based on the idea that there was an agreement, at least a concerted process, kind of a silent agreement, if you want, between the parties to reach 5 euros. So there was a silent understanding that we would price the same way. So this is the very narrow line between, let's say, being anti-competitive in breach of competition law and not in breach of competition. So is there kind of a silent agreement? Are you trying to reach a silent agreement, or are you just informing the market of your prices? So these are all the efficiencies. I mean, I'm not going to list them, but there are very strong efficiencies in disclosing the data. So there are efficiencies, of course, among competitors, but there are also efficiencies with the suppliers, there are efficiencies with customers, there are efficiencies with consumers, there are lots of them. I mean, the more transparent the market is, the better it is under certain circumstances. So, and there is an idea that, you know, a very transparent market is better for competition as well. Not necessarily, but it is true that consumers will have more information, competitors will have more information, customers and so on, which means that it would be easier, in theory, for them to constrain another company, say. So if I am the consumer and I know, for example, let's say I'm buying an airline ticket and I can have access to all of the prices at the same time and I can just compare them, it is much easier for me to actually buy the cheapest one. If I had to call each individual airline or to go on each individual website, for example, even, it would be much more difficult. So there are a lot of efficiencies, there are a lot of constraints coming from transparency. So in general, the idea is that transparency is good. So this doesn't need to change at all. Of course, there are exceptions, which is when the transparency enables companies to coordinate their conduct. So as we were saying before, you have access to each other's prices and you can coordinate on having one price. If you do that independently of each other and you just do it unilaterally based on you adapting to each other's prices, that is normally fine. The issue is when you actually are eliminating the uncertainty of competing with someone else. So when you price at 5 euros, you don't know that the others are going to price at 5 euros. You would know if you agreed before, or you would know in another situation that I'm going to discuss then, or you would know with much more likelihood. But if you just say, I'm going to price at 5 euros, here is my sack of cement, you want it for 5 euros. If you do that, then you don't know what your competitors are going to do. So they could just say, I'm going to price at 4.90. And then, I mean, you're stuck, at least for the time in which you are at 5 and this other one is at 4.90, the customers will move, right? So whenever there is still uncertainty, and whenever there is incentives to compete, so you have incentive to price at 4.90 instead of pricing at 5, and you are acting independently, it is fine. If because of the public exchange of information, and we're going to look into the specific cases, because I do see how it is difficult to actually find the specific situation in which this wouldn't be the case, but in case instead the public disclosure leads to all of this, so you just reduce uncertainty because you are telling the other side, I'm gonna price at 5 euros, whatever you do. I mean, don't worry, I'm gonna price at 5 euros, and so the other one is fine, and we'll just go in with 5 euros, and then you go in with 5 euros. So there is kind of a common understanding, let's say, that you will go in one direction. If that happens, then you are in a situation that can be in breach of competition. The data is the same as before. We already discussed this. It's exactly the same. I mean, the competitively sensitive information is the same under any possible interpretation. That there is a case-by-case analysis. We have to look at if it's strategic, aggregation, so individualized, or aggregated, and so on, age, historic, current, and so on, and the frequency of the disclosure. So as I was saying, I mean, if it's genuinely public, and this is the other element, so it needs to be really accessible in the same way for everybody, both in terms of costs and easiness and understandability. So it cannot be just, yeah, I mean, it is in the public domain, but you know, you have to pay a subscription in order to have access to receive it, for example, on the same day, or it is in the public domain because I discussed that at the conference, but you know, and the act of the conference is, yeah, you can ask for the act of the conference to the organizer and so on. So it is very different than actually being in the public domain, equally accessible to everyone. Any questions on this? Yes.
So at the end, we have actually more experience in Romania with those are talking
Nice.
So
Okay,
you can give very different interpretations. So it's a very interesting.
Okay, good.
That's why everybody is silent.
I think you get all your cases in Romania. Okay, that's very good. So, but yeah, so in theory, it should be on the same interpretation everywhere. So this is very good. I mean, of course, as we were saying before, I mean, it's in competition law needs to be interpreted and applied, and in a lot of cases, they reach different conclusions. But that shouldn't be the case. So, like, competition law should be the same, at least in Europe. In my opinion, everywhere in the world, because it's based on economic principles. But you know. Absolutely, I mean, and these are the most interesting, you know, cases, because then you know where you could lean towards. I mean, maybe someone is leaning in the wrong direction or in the right direction. So, cases. Okay. So there are 4 cases. Very quickly, I'm going to discuss them very quickly. This one is about the trade association. These 2 are about the actually public disclosure. So here you actually can see the difference between the, you know, what's lawful and what's unlawful under, I mean, according to the Commission and the Court of Justice. And here you can see another example of what is being considered unlawful by the Dutch competition authorities. So I'm gonna go. I mean, this is very go through this very quickly. I mean, it is just the issue of this case was that the trade association asks for very detailed data, which may be fine if it's necessary, and this wasn't the case. Apparently, the conclusion was that the data that was disclosed was much more than what was actually needed. For example, you wouldn't need export invoices to do, you know, the statistics, to create statistics and so on. So they were asking for more information about what was needed to do the statistics, let's say. And then in addition to that, they were also resending, let's say, so they were getting the information and then sending it back to the members unaggregated. So the idea is you can have a trade association that gets the data, aggregates them, creates the statistics, and then send them back to their members. But you cannot have a trade association that just acts as a hub and just gets all the information and then sends them back to each individual one, because then it's exactly the same as exchanging the information between them. So this was, let's say, a relatively straightforward case, at least based on the interpretation given by the Commission, of something that cannot happen. And in the end, the fact that it was within a trade association doesn't really matter. It's exactly the same as being in a small field room, as they like to say, and just exchanging information in order to coordinate. So the effect was that the members aligned on export pricing policy to the undertakings with the preeminent market positions. They were just looking at each other, what they were doing, and then they were saying, okay, so this is the biggest one, I'm going to do exactly the same as this one. So they were just doing the same in each individual market based on the one that was the biggest. So, classic case of an exchange of information, disclosure of data, in theory justified. Because, so if it was just going up and not going down, so the information was stopping at the association level, that would have been probably fine, as long as it was information that was actually necessary to do the statistics. So it's not like you cannot disclose information. What's important is that it doesn't go to your competitors in an individualized manner. So Woodpulp is a very, very, very famous case, very old case. I mean, anybody that studied competition law read this at least, or studied this. So in this case, it's interesting because there was a commission decision that fined the companies, and then there was a court decision that said the exact opposite. And So what happened here is that, let's go to the commission's assessment. So the commission said, okay, let's do the facts. So the facts were that there were wood pulp producers. These wood pulp producers had agreements, long-term agreements with their customers. And under these agreements, the maximum price was set each quarter. And it was set by a public announcement, right? So each quarter, the producers were saying, this month, this quarter, the maximum price is 10, okay? So each producer had these agreements, and each producer was doing these quarterly announcements a little bit before, the end of the quarter. So what was important is that there were agreements behind them, and therefore these announcements were binding, and they were the maximum. So it was not the minimum, it was a price, so it was the actual price, and we'll say why this is relevant. So it was 5 euros, it wasn't like I'm going to increase, and we'll see why this is relevant. I'm going to increase by 10%, which kind of doesn't give you the information to compare. You have to say it is 5 euros, and then the other one will say it is 5.1, or it is 4.9, or it is 5. So each had to do this. It was to ensure the, let's say, functioning of the contracts. It was normal market behavior in this market. And the customers could still negotiate a reduction of the price. All of this is very relevant because what the commission said is, well, but actually what you're doing is the 5 euros example, right? So you are aligning on 5 euros. You are telling everybody the maximum price is 5 euros, and then the next one will say, oh, it's 5 euros also for me, and then the next one will say 5 euros. So everybody, and this is actually what happened. So what was happening is that they were all pricing almost at the same time at almost the same price. So it was true that was happening. So it was true that the announcements were very similar, they were almost at the same time. But, and therefore, the commission said, okay, so there is a concerted practice. It can either be a concerted practice behind it that I couldn't discover, and I can see that you are acting in a way in which you could act only if you had an agreement before, or it is just a concerted practice on the market based on the fact that you're acting in the same way, you're charging the same prices, and you're just testing it, like speaking to each other, say, on the market. So you're just saying to everybody, including the competitor, I'm pricing at 5, and then this other one responds, okay, I'm pricing at 5 as well. What the court said is that it wasn't an issue. So it wasn't a breach. And the reason was that there was a reason for it. So the reason why they were doing it is that there were agreements. So they weren't just doing it to agree to align on prices. They were doing it because there were agreements, and apparently these agreements were to limit the buyers and sellers' commercial risks in long-term relationships. So the idea was that in that market it was justified. So there was an interest of both sides to actually have these announcements and have these type of contracts. At the same time, they were binding, so it was not just intentions. They were not just saying, I'm thinking about pricing at 5. They were saying, I'm pricing at 5. They were also happening almost at the same time, which means that they didn't really have the time to adapt to each other. So they were almost pricing at the exact same time. So they were not one saying 5 and then the next one. It was 3 of them saying 5 and then another 5 of them saying 5. So it was very, very close. The announcements were close to each other, so they didn't really know what the other one would price necessarily. And they were very close to the beginning of the quarter, which means that they couldn't change them. So they were not changing these announcements. So if I price at 5 and somebody else gets in at 4.90 for that quarter, the maximum price of this other one is lower. Then you can negotiate this on, but it's still the maximum would be lower, and then you have the customers negotiating. So the final price is not the one that I'm actually telling the market, it's the one that each individual customer can negotiate. There were other elements, but this is the reason why this was considered okay. Then you have this one. So what's interesting about this case is that, take into account that this was not there was no fine. So this was a commitment decision. So it didn't get to a fine, it got to an actual infringement decision, and it was not, and therefore it was not appealed. So this is the commission's position. It is much more recent. So you can assume that the Commission's position is this one. But the Commission always, of course, took into account wood pulp. So they wouldn't want, wood to go against wood pulp, but take into account that this was stopped, let's say, at the Commission level, and it was a commitment decision. So a lot of times you commit to stuff even if you don't agree with it. So what happened here is that you have something similar. So there were announcements, but in this case there were announcements of increases. So not prices, but price increases. So instead of saying I'm pricing at 5, it was saying, you know the price that I sold you the cement last quarter, this time I'm going to sell it to you at 10% more, right? And it was that. So the consumer did not know what the price was, neither the maximum or the minimum or the average. They didn't know anything. They just knew that the price would go up 10%. And it was done, it was 3 to 5 weeks, but just assume that it was done in giving enough time to the supplier to change it. So they were saying to the market, I'm going to price at 10% more, and then they were seeing what the others were doing. This is what the Commission is saying. Yeah? And they were seeing what the others were doing, and if the others were all saying 5%, then they were changing their announcement to 5%. Right? So they had the time to do that, and indeed they could do it because they had the time and because it was not binding. So it was just, I think about increasing by 10%. That was it. And then they were seeing what the others were doing and they could change and so on. So until the time in which the consumers actually could rely, let's say, on that increase, which still was an increase. So the customers could not know the price. And in addition, it was not even binding. So they could always say, yeah, I said 10%, but I'm actually going to do 20%. So it wasn't even binding in that sense, although, it is a bit complicated, I guess, to change, to tell someone that you're not going to do what you told everybody that you will do, but you can still change the announcement, for example. And this actually happened. So they did actually change their announced price increase. So this is the Commission's theory, and this is this is the most important part. So this is the case in which the public disclosure is an issue. So the public disclosure is an issue when you're not bound, so you can change it as much as you want. You have the time to align with the others. So you just say a price, or a price, in this case a price increase, which is even more easier to align on and more difficult for the customers to actually discipline. And you have the time to do it, and you do it based on the response of your competitors. So you tell the market, in this case, I'm going to price it 10% more, which also doesn't really give any information to the market except for your competitors, because you could be pricing at one competitor and another one at 10, and you can still agree, let's say, on a price increase. Well, if you were pricing at 1 and the other one at 10, it is very difficult to agree on a price. Because then you would be saying, no, but I don't want to increase my price because then I will lose customers. And then the other one would say, no, I don't want to decrease my price because I will make less money. So it is much more difficult to agree on price. So in this case, it was price increase, non-binding. It gave the time to actually test the market and decide without losing customers, because you were just testing. Right? So you could just, I was kidding. You could say, I was kidding, I'm going back, no, I'm not going to increase my prices. So this is the reason why the Commission intervened and said, we think this is anti-competitive. And what they did is they asked for wood pulp, pretty much. So they said, what didn't work was that they didn't know the price, like in wood pulp. They didn't have, you had the time to change it. So the idea behind this is that you don't have the time to change your price or your price increase before the customer start buying. So if I say €5 and then the customer buys at 5, I already lost a sale that could be a 6 if everybody else goes 6, for example, and vice versa. The customer that would have bought at that time doesn't come to me, it goes to somebody else because I'm pricing too high. So you shouldn't have the time to change your mind. And you have to be bound, so you cannot change your announcement just reacting to the others. And and the reason why this is fine, and let's say the situation in container was not fine, is that there is the idea that the consumer, in a genuinely public disclosure of data, when the market is very transparent, and is actually everybody has access to the same information in the same way, the other players in the market, so other competitors that are not participating, not making any announcements, customers, suppliers, and consumers that have access to the same data can use it against those that actually want to align. So you have 10 players that try to align, and there is the 11th that says, no, I'm actually a maverick, I want to price lower. If the consumers have the exact same access to data and knows everything, it is very likely that the consumer will move to this 11th, and then the others will just stop, and they will just keep on competing as normal. So that is the idea behind the public disclosure of data. If it's, summary slide. Yes, so as long as it is actually public, generally public, and everybody has access to it, and they can use it to constrain your conduct, normally it's fine. The more you move away from it, the more difficult it gets to actually justify what you're doing. I'm going to just say what this is. So what happened here is a similar, let's say, situation. It is interesting because the disclosure was at a conference, so the authorities said, yeah, it's actually not the same as disclosing to the public, and then it was an intention, and it is interesting because you could see the response. So they used internal documents, and they used also announcements, but what happened is that one announced that they would increase prices, let's say, to make it easy. The other one responded, said that they were thinking about increasing prices, sorry. And the other one said, I really hope they do that. And then they do it. And then they, at the same time, they were thinking about doing it internally, right? And then they do it. And then the other one, the third one, said, internally, was saying, yeah, so considering that this one said that they will increase, and this one said that he is actually he really likes the idea, I'm going to do the same. So, so this is what this case was about. So you can see how it was interpreted and so on, but like the idea is always the same, right? So it is an intention. It is, in this case, it was also happening in conferences or like specialized press. It was the companies were looking at each other when they were doing it. So it may be a problem, but take into account that also this case was concluded with commitment. So all of these cases are very, very borderline. I mean, the authorities have a lot of difficulties in bringing these cases. So even if you're in these situations, actually getting to an infringement decision, it's very, very difficult because they are so borderline that it is very, very easy to push it in one direction or the other. So they normally end with commitments. And I mean, in Italy there was something similar in the relatively recently with a change from the month. It was, I don't know whether you have ever heard of this, but like it was in telecom, and all of the operators changed from a month of 30 or 31 days or whatever, like the normal month, the calendar month, to a 4 weeks month. So you had 1 week, I think, at the end of the year, or maybe more actually. No, you had 4 weeks at the end of the year. And so they did it together at the same time. And as far as I know, they thought about bringing an antitrust case. Maybe there will be an antitrust case at a certain point, but then they resolved it with regulation. So you do have a lot of these kind of like very borderline cases where you think that they have agreed upon something, but you cannot really show it. You cannot demonstrate it. So there are a lot of, it's very difficult, let's say, for these cases to actually get to a decision. Just for you to know, in this slide, there is a list of things that a company can do, even just internally. So the idea is like, you can start preparing, let's say, the evidence in case they start a case against you. So you just, yes, I am disclosing to the public, but like confidential information, but it is really the public, it is the entire public, it is unilateral, I'm not looking at my competitors, it is normal market behavior, this is what everybody does, and it is pro-competitive, it's pro-consumer, it's very good for consumers. So even in internal documents, one can already start, avoiding, let's say, antitrust liability. But you have the slide.